Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of banking and finance law, negotiable instruments and service law. To know more about them, please watch the video fully. In the important judgment titled NKGSB Cooperative Bank Limited versus SUBIR, CHAKRAVARTY and others, pronounced on 25th February 2022, the Supreme Court has held that the district magistrate or the chief metropolitan magistrate can appoint an advocate commissioner to assist him or her in execution of the order passed under section 14(1) of the SURFACI Act. The facts of the case would be that the orders of district magistrate or the chief metropolitan magistrate appointing advocates in exercise of powers under section 14(1)(a) to take possession of the secured assets and documents relating thereto and to forward them to the secured creditor were challenged before different high courts. The Bombay High Court held that the advocate, not being a subordinate officer to the district magistrate or the chief metropolitan magistrate, such appointment would be illegal. The Madras High Court took a contrary view, holding that the advocate is regarded as an officer of the court and thus subordinate to the district magistrate or the chief metropolitan magistrate. The High Courts of Kerala and Delhi also took the same view taken by the Madras High Court. Being agreed, present appeals have been filed before the Supreme Court with an issue posed for consideration, and that is whether the district magistrate or the chief metropolitan magistrate can appoint an advocate in exercise of powers under section 14(1)(a). The Supreme Court has held that section 14(1)(a) states that the district magistrate or the chief metropolitan magistrate may authorize any officer subordinate to him to take possession of such assets and documents relating thereto and to forward such assets and documents to the secured creditor. Section 38 empowers the central government to make rules for carrying out the provisions of the SURFACI Act. Subsection 2 thereof does not specifically or expressly refer to power to make rule in respect of matter provided for in section 14, unlike other provisions noted therein. However, it is open to the central government to frame rules in that regard by invoking clause G of subsection 2 of section 38. Pertinently, no such rule has been framed by the central government in reference to subsection 1(a) of section 14, much less to expressly or by necessary implication prohibiting the district magistrate or the chief metropolitan magistrate to engage an advocate commissioner for taking possession of the secured assets. In absence thereof, exclusion of engagement of an advocate as commissioner cannot be countenanced. Subsection 1(a) of section 14 is no impediment for the district magistrate or the chief metropolitan magistrate to engage services of an advocate only for taking possession of secured assets and documents relating thereto and to forward the same to the secured creditor in furtherance of the orders passed by the district magistrate or the chief metropolitan magistrate under section 14(1) in that regard. It does not follow that the advocate so appointed needs to be on the rolls in the office of the district magistrate or the chief metropolitan magistrate or in public service. There is intrinsic de jure functional subordinate relationship between the district magistrate or the chief metropolitan magistrate and the advocate. The apprehension of the borrowers about improper execution of orders of the district magistrate or the chief metropolitan magistrate passed under section 14(1) by the advocate commissioner is plainly misplaced. Further, being an officer of the court and appointed by the district magistrate or the chief metropolitan magistrate, the acts done by the advocate commissioner would receive immunity under section 14(3). There is no reason to assume that the advocate so appointed would misuse the task entrusted to him or her, and that will not be carried out strictly as per law, or it would be a case of abuse of power. Rather, going by the institutional faith or trust reposed on advocates being officers of the court, there must be a presumption that if an advocate is appointed as commissioner for execution of the orders passed by the district magistrate or the chief metropolitan magistrate, that responsibility and duty will be discharged honestly and in accordance with rules of law. Therefore, it would be open to the district magistrate or the chief metropolitan magistrate to appoint an advocate commissioner to assist him or her in execution of the order passed under section 14(1). Thus, the judgment and order of the Bombay High Court is declared as not a good law. Coming to the next important judgment, titled TRL Krosaki Refractories Limited versus SMS Asia Private Limited and another, and pronounced on 22nd February 2022. In this judgment, the Supreme Court has held that in a check bounce case, when the complainant or payee is a company, an authorized employee can represent the company. The facts of the case would be that the appellant filed a complaint before the subdivisional judicial magistrate under section 138 and 142 of the Negotiable Instruments Act 1881. The subdivisional judicial magistrate took cognizance of the complaint and directed summons to the accused. The accused filed petition under section 482 of CRPC before the ORISSA High Court, which held that there is no mention in the complaint or affidavit as to when and in what manner the company authorized its general manager to represent it to file the complaint. Being aggrieved, present appeal has been filed with allegation that the High Court misconstrued the principle enunciated in AC Narayanan versus State of Maharashtra, another, reported in 2014-11 SCC 790 to non-suit it. Whereas the accused submitted that there should be explicit averment to the effect that the person filing the complaint is authorized by the complainant and has knowledge of the transaction in question so as to maintain the complaint. The issue posed for consideration is whether the complaint filed by the appellant under section 138 is in accordance with the requirement under section 142. The Supreme Court has held that when a company is the payee of the check based on which a complaint is filed under section 138, the complainant necessarily should be the company which would be represented by an employee who is authorized. Prima facie, in such a situation, the indication in the complaint and the sworn statement to the effect that the complainant company is represented by an authorized person who has knowledge would be sufficient. The employment of the terms specific assertion as to the knowledge of the power of attorney holder and such assertion about knowledge should be set explicitly as stated in AC Narayanan case cannot be understood to mean that the assertion should be in a particular manner, much less only in the manner understood by the accused in the case. All that is necessary is to demonstrate before the magistrate the complaint filed is in the name of the payee, and if the person who is prosecuting the complaint is different from the payee, the authorization therefore, and that the contents of the complaint are within his knowledge. When the complainant is a company, an authorized employee can represent the company. Such averment and prima facie material is sufficient for the magistrate to take cognizance and issue process. If at all there is any serious dispute with regard to the person prosecuting the complaint not being authorized, or if it is to be demonstrated that the person who filed the complaint has no knowledge of the transaction, and as such that person could not have instituted and prosecuted the complaint, it would be open for the accused to dispute the position and establish the same during the course of the trial. Therefore, entertaining a petition under section 482 of CRPC to quash the order taking cognition by the magistrate would be unjustified when the issue of proper authorization or knowledge can only be an issue for trial. Now we are going to deal with the important judgment titled MUKESH, KUMAR and another versus the Union of India and others, pronounced on 24th February 2022. In this judgment, the Supreme Court has held that a compassionate appointment policy cannot discriminate against a person only on the ground of dissent by classifying children of the deceased employee as legitimate and illegitimate. The facts of the case would be that the deceased, who was an employee of the Indian Railways, had two wives. After his death, the compassionate appointment plea of the deceased employee's second wife's son was rejected, citing the condition imposed by the Railway Board circular that compassionate appointment cannot be granted to children born from the second wife of a deceased employee. The appellants filed an original application before the Central Administrative Tribunal, which dismissed the same. A writ petition was filed before the Patna High Court, questioning the correctness of the decision of the tribunal. The division bench, however, dismissed the writ petition. Being aggrieved, present appeal has been filed before the Supreme Court, where an issue is posed for consideration, and that is whether the condition imposed by the Railway Board circular that compassionate appointment cannot be granted to children born from second wife of a deceased employee is legally sustainable. The Supreme Court has held that the matter is no more res integra. This court in Union of India versus V.R. Tripathi, reported in 2019-14 SEC 646, considered the very same policy and circular that arise for the consideration in the present case. The scheme and rules of compassionate appointment cannot violate the mandate of Article 14 of the Constitution. 1 Section 16 of the Hindu Marriage Act regards a child born from a marriage enter into while the earlier marriage is subsisting to be legitimate. It would violate Article 14 of the Constitution if the policy or rule excludes such a child from seeking the benefit of compassionate appointment. The circular creates two categories between one class, and it has no nexus to the object sought to be achieved. Once the law has deemed them legitimate, it would be impermissible to exclude them from being considered under the policy. Exclusion of one class of legitimate children would fail to meet the test of nexus with the object, and it would defeat the purpose of ensuring the dignity of the family of the deceased employee. While compassionate appointment is an exception to the constitutional guarantee under Article 16 of Constitution, a policy for compassionate appointment must be consistent with the mandate of Articles 14 and 16. That is to say, a policy for compassionate appointment which has the force of law must not discriminate on any of the grounds mentioned in Article 16(2) of the Constitution, including that of dissent. In this regard, dissent must be understood to encompass the familial origins of a person. Familial origins include the validity of the marriage of the parents of a claimant of compassionate appointment and the claimant's legitimacy as their child. The policy cannot discriminate against a person only on the ground of dissent by classifying children of the deceased employee as legitimate and illegitimate and recognizing only the right of the legitimate descendant. Apart from the fact that strict scrutiny would reveal that the classification is suspect, as demonstrated by this court in V.R. Tripathi case, it will instantly fall foul of the constitutional prohibition of discrimination on the ground of the dissent. Such a policy is violative of Article 16(2) of the Constitution. Therefore, the judgment and order of the High Court is set aside. As appellant number 1 cannot be denied consideration under the scheme of compassionate appointments only because he is the son of the second wife, there shall be a direction to consider his case as per the extant policy. The authorities shall be entitled to scrutinize whether the application for compassionate appointment fulfills all other requirements in accordance with the law.